Our next case is Ithaca Finance LLC versus Leisure. It is an appeals court case concerning tax foreclosure. A private firm, Plymouth Park Tax Services LLC, entered into an agreement with the City of Lawrence to purchase delinquent real estate tax receivables pursuant to Chapter 60, Section 2C. Plymouth Park was then assigned the right to collect these receivables, including taxes on a Bunker Hill Street parcel owned by Felicia Hilario. For unpaid fiscal year 2008 and 2009 taxes, Plymouth Park recorded an instrument of taking at the Registry of Deeds in February of 2010. In July 2012, Francisca Leisure bought the subject property from Hilario. Leisure maintained that she was unaware of the unpaid taxes when she purchased the property. Then, in March 2014, Plymouth Park assigned its rights to another private firm, Ithaca Finance LLC. On March 31, 2014, Ithaca sent a letter addressed to both Hilario and Leisure, who resided at the subject multifamily property. The letter contained an assignment of real estate tax lien for that property. Subsequently, Ithaca filed a foreclosure petition in land court in May of 2014. Ithaca listed Hilario as the owner of the property and did not list Leisure as a defendant. Ithaca later amended its foreclosure petition to include Leisure, and the land court issued a special citation notifying Leisure that Ithaca had filed a foreclosure petition against Leisure for the property. The notice from land court also informed Leisure how to respond and the date by which to answer or risk default. The citation was sent by certified mail, return receipt requested. Leisure took no action, and land court in May 2016 entered final judgment foreclosing Leisure's right of redemption. Ithaca consequently took free and clear title to the property. By statute, in Chapter 60, Section 69A, however, Leisure could have filed a petition to vacate the foreclosure decree if full payment was made within 1 year. In this instance, Leisure again took no action, and Ithaca notified Leisure in June 2017, a mere 2 weeks after the statutory redemption period had expired, that she owed rental payments on the property. Leisure then filed a motion in land court for relief from the foreclosure judgment. Leisure argued that Ithaca had violated her due process rights by failing to follow the provisions in the statute for the assignment of the receivables. Specifically, Chapter 60, Section 2C required Plymouth Park to notify the City of Lawrence and the owner, Leisure, of the receivable assignment from Plymouth Park to Ithaca within 12 business days. The statute also provided that Ithaca, as a successor in interest, was expressly required to communicate with taxpayers and assist them in their repayment efforts before seeking foreclosure. The land court judge, ruling on Leisure's motion, held there had been an inequitable foreclosure, and the foreclosure decree could be vacated beyond the 1-year statutory period. On appeal, the appeals court held that Leisure was not denied her due process rights. Land court had notified her by special citation, and Leisure's signature appeared on the green certified mail receipt indicating she received notice of the foreclosure action. Notice by certified mail is required by state statute and satisfies constitutional due process requirements. Once the land court issued the foreclosure judgment, the 1-year redemption period began to run. The appeals court wrote that Ithaca had no legal obligation to notify Leisure of the foreclosure judgment. While the appeals court sympathized with Leisure's situation, the court held that Ithaca's failure to follow the procedures and communication rules set forth in the assignment statute did not rise to the level of a violation of due process. In fact, the appeals court could find no case supporting the claim that a foreclosing party's violation of the assignment procedures represented a denial of due process. In the absence of a due process violation, the appeals court held the legislative intent was for the public interest in marketable title to outweigh individual hardship after the 1-year period. A further appeal to the Supreme Judicial Court was denied. As a result, the land court's order granting Ledger's motion for relief from foreclosure was vacated, and Ithaca now owned the property.